それではこれより論文発表5、特許制度の経済学を行います。議長は元経済、公共政策研究所所長、フランダイス大学名誉教授のアダム・ジャッフェ様に務めていただきます。論文発表者は5名いらっしゃいます。一橋大学イノベーション研究センター。
We're very pleased to begin the fifth section of the thesis presentation. And we have Professor Nagaoka, Elizabeth Webster from University of Melbourne, and Mr. Sebastian Stoll from Max Planck Institute for Innovation and Competition, and Mr. Michael Frakes, Northwestern Law School, and NBER, as well as Ms. Melissa Wasserman, University of Illinois College of Law.
Okay. Thank you very much. It's a great honor to be here at this conference, and I appreciate the invitation, and I'm very also honored to chair this panel. I'm not going to talk. I'm just going to introduce the speakers. We have 4 papers being presented, so we'll need to move along. Our first presenter is Professor Sadao Nagaoka from Hitsubashi University here in Tokyo. I've heard several times during this conference introducers saying that someone needs no introduction. So I was thinking about what does that mean? And I think what it means is it implies that you don't need to be told much about this person because you know the facts already. But that actually doesn't make much sense because the facts are all in this book anyway. So the purpose of an introduction can't really be to present you with facts. I think the purpose of an introduction is to honor the person being introduced. And so in this case, it would be very wrong for me to say he needs no introduction, because I think we all owe a debt of honor and gratitude to Professor Nagaoka. In addition to being a pioneer of research using patent data and Japanese patent data, he's also, I know from personal experience, the reason why a number of us came to Japan for the first time, having been the gracious host of several of us to have visited Japan. So it really is a pleasure for me to introduce him, for him to give his talk on grace periods in the Japanese patent system. Thank you.
Thank you very much for your very kind introduction. So this study is based on a joint work with Professor Yoichiro Nishimura, who is a professor at Kanagawa University, but he's currently visiting University of Washington. And this study is also partly based upon the study commissioned by the JPO to the Institute of Intellectual Property. So the issue is the grace period. Okay. So this is the outline of my presentation. So let me start with the background research objective. And as we all know, one of the most important differences among the national patent system lies in the grace period system. In the United States, it is automatic for 1 year, while there is almost none in Europe, and Japan is in between. And one of the point which this paper argues, the necessity of harmonization is increasing, because the increasing globalization patent applications has made the search for the best system and harmonization patent system toward that goal more urgent. The objective of the paper has the following two. The first is to assess how significantly the globalization of the patent applications can account for the recent deduction of the use of the grace period exception in Japan. Secondly, to assess how significantly the grace period system promotes the knowledge flow to the third parties in order to assess the economic effects of the grace period system. There is very small number of empirical studies on this issue, significantly due to the design of the grace period, which I already mentioned. In the United States, it is automatic, so there's no record. In the Europe, grace period is not accepted, so again, there's no record. But in the case of Japan, 6 months grace period is allowed. However, it requires applicant to notify the prior scientific disclosures. So therefore, this basically gave us the patent paper match so that this allows, again, to assess the issue like knowledge flow. So briefly, the grace period in Japan, so 6 months, unlike 1 year in the United States. And the scope of the prior disclosure allowed significantly liberalized over time. The important reforms was year 2000 reform. Basically, it liberalized the use of internet site for publications. And the next major reform is 2011, where all forms of public disclosures are eligible. So in terms of the coverage of the prior academic disclosure, the Japanese system is quite close to that of the United States. The only difference is the notification is allowed, and also the term is just 6 months. Our data covers 1992 to 2008, so we cannot really assess the 2011 reform, but our data covers 2000 year reform. So we found that exhibitions account for only around 5% of the use of the grace period. So basically 90% of the disclosures are academic disclosures. That's a very important finding. And secondly, corporations are actually very important. Corporations account for around half of the use of the grace period. So this data shows the average intensity of the use of grace period exception by type of applicants. So private companies very small, just 0.1% of their applications use grace period. So they're basically exceptional thing. However, academic institutions like universities, they 14.6% of their applications use grace period. The similar numbers for TLO, about 14.1%, 9.6% for professional organizations like national research laboratories. This shows the composition of the use of grace period by academia, corporations, and individuals. And the red part represents the corporations, because most of the engineering scientific research are done by the National University of Japan, and National University did not have legal persons until the corporatization of the Japanese National University system in 2000. So that is the reason why most of the exceptions were used by corporations in 1990s. However, in 2000s, after the corporatization of the Japanese National University system, about half of the use of the grace period is done by academic institutions. So this shows the variation of the use of the grace period by sectors. As you may expect, genetic engineering or biological sector or pharmaceutical are the major users. But still, most sectors actually use grace period. So I think the science is a very important part of the innovation process in most of the technological sectors. So the first issue is the globalization of the patent applications and the use of the grace period. This shows the two graphs. One red part is the percentage of the use of PCT routes by the Japanese applications. And it increased from about 2% in early 2000s to around almost 18% in 2008. So this shows the increasing use of the PCT routes by the Japanese applications. This blue bar shows the use of the grace period. So I mentioned earlier that there was a major reform in 2000. So after that, there was a sharp increase of the use of grace period from about 0.3% to about 0.6%. However, after 2004, starting from 2004, basically it tends to decline. What happened in 2004? In 2004, there was a reform of the PCT, because PCT basically moved to, basically PCT filing system was reformed, that basically designation of state rules was abolished in 2004. And after that, PCT application gives its applicant a bundle of options to apply for a patent in any number of countries within 30 months from the priority date. That means that you have an option. If you go to the PCT route, you have an option to pursue applications in Europe in 30 months. So I think that the option for going to Europe has become very much increased after 2004 reform of the PCT. So two evidence of the effects of the globalization. And this shows the use of the grace period by intensity of the use of the PCT. And so we classify the sectors into three parts. That is, the sectors with very high intensity of the PCT use, and then the lowest and the middle. And the use of the grace period declined significantly for the sectors with high intensity of the use of PCT. However, we didn't see any such change for the low low intensity of the PCT use. This compares the use of the grace period on the basis of academic disclosures versus on the basis of exhibitions. So 2004 reform really did not change the use of the grace period on the basis of exhibitions. However, it had a major effect on the basis of the academic disclosures. So because there was no international, there is a grace period based on international exhibitions across the world. So PCT reform should have no effect on the use of the grace period based upon the international exhibitions, but there's a huge difference for the application rule of grace period for the applications based on academic disclosures. So we can see such difference from coming from this graph. We will investigate the significance of this later in econometric exercise. So let me move on to the second issue, that is the economic effects of grace period. There are actually three views of the effect of grace period. First one is acceleration of the disclosure. That is, it promotes an early disclosure of research output, since early disclosure does not constrain the patentability of the invention. And in the case of corporations, IPR department requires researcher to publish only after filing a patent or after its disclosure. But if there is a grace period, you can allow your researcher to publish before the patent application, because that does not constrain the patentability, although it does constrain the patentability in Europe. So this is the first view. But there's a second view, that the deferral of domestic patent filing view. Basically, it allows the applicant to postpone the filing of the patent application. And this view is expressed by Van Bottelsberg, saying that the authors of published material reserve their inventions for a certain period of time without the inconvenience of or cost of filing a patent. So this is the second view. And there's also a third view, that is promotion of domestic patenting view. And according to the recent survey over the European TTOs, around 50% of the respondents say that the loss of patent protection due to premature public disclosure occurred very often or fairly often. So basically, academics do not really ignore the patenting propensity and patenting opportunities. So therefore, if there is a grace period, they can patenting. So that's the third view. the question is how we can differentiate these three views. And basically, my view is that one very effective way is to reassess the knowledge flow effect, because this shows the differentiation of the three views. Basically, only under the acceleration of disclosure view, the disclosure, academic disclosure is accelerated. There are, under the academic acceleration of disclosure view, if there is a grace period, academic disclosure takes place early and then patent application. But if there's no grace period, actually they may take place simultaneously. But under the other two views, basically academic disclosures take place irrespective of the use of the grace period. So therefore, if this view is very important, we will see the effect of the early academic disclosure over the third parties. That's basically the idea of this research. And also, there are the other identification, that is, the determinants of the use of grace period also provides information, which view is more correct at the margin. That is, if acceleration of disclosure view is held, the use of the grace period tends to increase with its science linkage, while its use declines with private value of the patent, because the basic trade-off is that if you allow your researcher to publish early, you can give that researcher academic priority, but you lose the chance of filing in Europe. So if the patent is very valuable, the company will not allow the early academic disclosure. But on the other hand, if academic value is very important, of course, that tends to work for the use of the grace period. So there is this trade-off. But this trade-off does not exist for the other two views. So basically, we can also assess how the use of grace period varies with the science intensity of the research, but also the value of the patent. So let me jump to the results of the estimations. So basically, as far as the knowledge flow analysis is concerned, we use inventor non-self-forward citations to assess the effect of the grace period. And basically, why we use non-self citation? Because self-citation, grace period does not affect self-citations. So self-citation actually can be used as a benchmark, as a control over the heterogeneity of the patent which we do not observe. And so basically, so we can control unobserved heterogeneity by taking the difference between the non-self-forward citations and self-forward citation, where self-forward citations are not affected by the grace period, because anyhow, that's the inside information. And also, actually, we use the level of science linkage which is defined as the number of backward science literatures disclosed in each patent. Okay, I have enough time. And so let me just explain the results of the estimations. So basically, what we did is very simple. That is, we have two sets of citation flows. That is, patent citation flows by the company, by the applicant, but also the other companies to the patent with or without grace period. So we have the dependent variables here are the own self-citation flows to the patent, and then this is the non-self citation flows, forward citation flow to the patent, and they are the dependent variables. And the explanatory variables is a dummy for the use of the grace period, and also number of claims, this measures the private value of the patenting, and then science linkage, that is science linkage. And the results of the estimation here, that is, if there is a grace period, if the patent uses a grace period, that if there is early academic disclosure, the citation by other increases about 2.7 percentage point, very significantly. And if there is a grace period attached to the patent, self-citation actually declines by about 2.8%. And very convincingly, both citations increase with the science intensity by the same degree. So this is the difference of the two citation flows. So basically, this is actually the results. And if there's a grace period, the knowledge flow to the third parties increases by about 6 percentage point. And that effect is larger if the third parties are small and medium-sized enterprise. SMEs, about 6.1%. For large firms, about 2.7%. So controlling for the heterogeneity by using the self-citation as a control, and also introducing the science linkage as a control, we do see a significant effect of the grace period accelerating the knowledge flow to the third parties. So this is the first result. And the second result is the use of the grace period. And so I will not show the details, but this is the results. And so dependent variable here is that whether the grace period is used or not. And explanatory variables are basically science linkage. And we'd like to see, I will just skip this. And then the number of inventors, number of claims, and also this is a sector level variable, that is, yes, whether PCT reform 2004, this is a 2004 PCT reform. And this PCT is a PCT intensity of the sector. So basically, the negative sign means that the PCT intensive sector experienced reduction of the use of the grace period after the 2004 PCT reform, very strong. And then, in addition, we see more use of grace period if the invention is science intensive. However, if the patent has more claims, it's not going to be used, the grace period. So this is very much inconsistent with the hypothesis which I said earlier. The basic trade is, if trade-off is between whether you get the academic priority or you lose the patenting opportunities in those countries where you don't have the patent. You will lose the patenting rights. So that trade-off seems to be very important. So let me just conclude. We have found a significant evidence for the negative effect of globalization patent applications on the use of grace period in Japan. This may not be seen in the United States because US has a very large market, but in the case of Japan, external market may be also very important. So I think that patenting opportunities abroad is a very important, seems to be very important consideration for the use of the grace period. And secondly, the grace period enhances the knowledge flow to the third parties. And because grace period is a voluntary decision, because therefore both the inventor and the third party are likely to gain from the grace period system. So therefore, I think that the probably grace period is a good system for the economic welfare. And there are, of course, design issues like transparency of the grace period. And in the case of Japan, there is a notification of the earlier disclosure. This would help. And also, early publication of the patent application reliant on the grace period may be very important because third party may not know whether the prior academic disclosure may turn into the patents or not. And that early notification of that decision may be helpful for the third parties. Thank you very much.
Thank you. Our next presenter is Beth Webster, who comes to us from the University of Melbourne, where she is a professor and also director of the Intellectual Property Institute of Australia. Beth has written widely on the economics of innovation, intellectual property, firm performance. She's a board member of the Asia Pacific Innovation Network, and we're very pleased to have her here.
Thank you very much, Adam. So first of all, let me thank you all for being here today. It's a pleasure to be able to address you. Thank you to the OECD for organising the conference and the JPO. And a special thank you to Maria Grazia and Ken Moria for their behind-the-scenes work organising the conference. So as you can see, this is joint work with three of my colleagues from Melbourne, Gaeton de Rassenfoss, Alphonse Palancanray and Paul Jensen. It's also a joint, as a collaborative project with IP Australia and our local Patent and Trademark Attorney Association. So the question I'm going to ask for this research paper is very straightforward and simple. It is, when patent officers examine a patent application, do they treat local inventors on equal footing with foreign inventors? Is the national treatment principle upheld? Now, the reason why this is important actually goes back over 100 years to the debates they had in the 19th century, where they realised that if an inventor could only get a patent in their own country, then the patent system wouldn't be a very effective means for stimulating innovation and invention. But if they could get a patent in other foreign countries, they would get more royalties for their invention, and thereby the patent system would give a greater stimulus to invention, or else they could reduce the royalty per unit sold, either way. So the countries realised that it was a positive-sum game to recognise other people's inventors and treat them in exactly the same way that they treat their own locals, and just judge the application based on the substantive measures of patentability, inventive step, novelty and utility. So way back in the 1870s, when they were designing the Paris Convention, they brought in the principle called national treatment, which means give locals and foreign inventors equal treatment in the examination process. And part of the reason it had to be equal, couldn't be just 90% or 80% as good, was because if one office started discriminating against foreigners, by just 10 or 20%, that might induce reciprocal action and the whole thing could unravel. Now, this is enshrined in law. It's in Article 2 in Paris Convention, 3 in TRIPS. But to date, there's only a limited number of studies that have actually said, well, it's in law, does it work in practice? And that's what I'm going to do today. Explain to you what we've done to try and test whether this principle's been upheld. So you know the system, but I'll just go over and explain what's happening here. Take a very simple case where we have an inventor from the US called John Smith. He has a priority filing in his own home country, the US. He also takes out a second filing in Europe and in this case, China. We have another inventor, Zhang Wei, who's Chinese. He has another invention. It's different, obviously, but it's of the same quality. It has the same embodied inventive step. So he takes out a priority filing in his home country, China, and also has second filings in US and Japan. And the question we ask is Zhang Wei more likely to get a patent in China than John Smith? They're both equivalent. They both have the same embodied inventive step. They're both novel. Is John Smith just as likely to get a patent in the US as Zhang Wei? Now, if they're both equally likely to get a patent in each of the offices, Zhang Wei and John Smith are just as equally likely to get in the US and just as equally likely to get in China, then the national treatment principle is being upheld. Now, you can say, OK, well, if we want to see whether the national treatment principle is being upheld, we can just compare the grant rates for locals and the grant rates for foreign inventors. And by local and foreign, I mean here principally the address, the residential address of the inventor. But you can't just compare aggregate grant rates because the underlying quality of the invention could be quite different. So you could say, okay, well, foreigners get a lower grant rate in Office A, and that's because their inventions are not very good. Our local inventors have better inventions, which is a fair argument. That might be true. So there's two other studies that have looked at this issue. The first by my co-authors and myself looking at the EPO and JPO, and the other by Stefan Wagner and his friend looking at China. And they do find some evidence that the national treatment principles not being upheld. But these studies actually look at applications from the 1990s, and our study only looked at the Paris Convention. So what we're going to do today is we've extended that study. We've extended it to the 5 large IP offices, including US, China, Korea. We're updating it. We're looking at priority years from 2000 to 2006. We can't take it any further into the future because we get data truncation because of the delays in the examination process. We're looking at both the Paris and the PCT routes. So how do we control for the underlying quality of the invention? Well, we use a very well-known technique which is called looking at equivalents or identical twins or identical triplets or quads or quins to net out the effect of the quality of the invention. And this is a very old technique, it's a very clever technique, and the geneticists, people studying psychology and things like that use actual identical people twins to do the same thing. Now, in the dataset, when you construct a dataset based on equivalence, it falls directly out of the PatStat database. You find that you get a different relationship. Sometimes you get a one-to-one relationship, so one priority filing leads to one secondary filing in the other office. But sometimes you have one-to-many or many-to-one. Now, what we have said is we're only going to look at the first categories, where you've got a one-to-one relationship between the priority filing and the number of filings in the other office or the other offices. Because that's so we can be sure that we are comparing the same quality applications when we do our statistical analysis. So this is just the equation we use to estimate our regression procedure. If you don't like equations, just listen to what I say and just ignore the figures there. It's very simple. We call it a reduced form equation. It says the grant decision, yes or no, depends on the quality of the underlying invention, the country, because I haven't written it up there, but the office, because we know offices have different degrees of difficulty or of getting a grant, and that's not what we're looking at here, the construction of the claims, and we're going to throw in a variable called whether or not the inventor is local to that particular office or not. And again, we have this very, very standard but very clever technique called a fixed effect binary logit model that means that we can net out the effect of quality without having to measure it. So that's essentially what we've got. We've got one priority filing, and it's only got one other secondary filing at each of the 5 offices, or depending on how many it's gone to. We're going to also do another limitation on the data just to make sure we're really sure we've controlled for quality by limiting the sample to the same DocDB family and by controlling for the number of ex-ante claims in the application. So we're going to limit the sample as well. To do the estimation, we combine data from 7 different sources. PatStat's the backbone of the data source. I mean, it's a fabulous data set. Why would you look elsewhere? But it doesn't have everything we want in it, so we had to go to different sources, principally to get numbers of ex-ante claims, and secondly, because PatStat wasn't totally up to date. So in terms of examination outcomes. So our examination outcomes are up to date as of a few months ago. Just a few descriptors of the data set. This tells you how many, we've got just nearly 800,000 distinct families, over nearly 2 million applications. Most of those are just two application families, but we've got about just over 200,000 that go to the 5 offices. This gives you an example of the outcomes from the different applications based on how many applications are in each family. So the green says the application, the family was granted in every office it was applied for, and the red said it was refused in every office. So they're what you call consistent or harmonious outcomes. The yellow is where you've got mixed outcomes. So this is just background information. We're not looking at the issue of disharmony per se. But it just shows you that even when you've only got two applications in a family, 40% have a mixed outcome. This is just descriptive background information. This tells you the strength of the ties between the offices. So the thicker the line, the greater the number of applications going to families with both those offices in it. It shows you that the links between the traditional three triadic offices of Europe, Japan and the US are still the strongest. Again, a bit more descriptives. This tells you the proportion in our data set of inventors who are local to that office. The highest is Japan. The lowest is China. China's down the bottom in the royal blue. Japan's at the top in purple. Yes. Dear, I did press the wrong button. Sorry. They're very close together, those buttons. Oh, thank you. This tells you the percentage going through the PCT route. It's very high for the European applications, and it's the lowest for Korea. So here are the results from the reduced form regression. It's a conditional logit, so we end up with just over 500,000 applications in the main regressions. The first four rows just tell you their control variables. It just says what office the application was sent to, and embodied in that is the difference in the level of the inventive step in each office, which we're not looking at. But most importantly, we're looking at columns 2, 3 and 4 and the red coefficient I've highlighted there, which says that yes, there is a bias towards local inventors. That is, if you're a local inventor and you turn up to your office and ask for an application, you're more likely to get a grant. And I'll convert that into a more intuitive number in a minute. But also we did then put in what's called interactive terms between being a local inventor and being going to each office to find out what is the difference between offices in terms of how much they favour their locals. So here is the actual what we call marginal effects, and they're simulated. So in the very first column, it tells you what the advantage it is to be a local in each of the 5 different offices. So China has the lowest and Korea has the highest advantage given to locals. In the second column, we limit our sample to applications that go through the PCT route. So this is quite interesting, but this is, I must say, this is still work in progress. But what it shows you is that in 2 of the offices, China and the US, when the applications are just going through the PCT route, and I understand this is just when the whole family goes through the PCT route, the bias towards locals is insignificant, it falls to 0. In the third column, that is the marginal effects when we limit our sample to that very narrow version of identical twins, triplets or what have you, and they do confirm roughly the same sort of results in the first column. So just to conclude, we did a few robustness tests looking at local applicant, the address of the applicant rather than the address of the inventor. The results are the same. We defined being a European differently. The results are still held. We do confirm the existence of a local inventor bias, suggesting that the national treatment principle is not being upheld. It's not close to being upheld. But on a positive note, we do find that the PCT route in number of offices does tend to mitigate that effect. Thank you very much.
Thank you, Beth. So our next speaker is Sebastian Stoll, who is presenting a paper that is joint work with Dietmar Harhoff. Sebastian is a research fellow at the Max Planck Institute for Innovation and Competition in Munich, where he recently completed his doctorate in economics. Welcome to the fraternity of economists studying patents.
Okay, thank you. Before I start, I'd like to thank all of you and especially the organizers for giving me the opportunity to present our work here. The project I will try to give you an overview of is joint work with Dietmar Harhoff, who was spoken here already yesterday. And in our project, we ask whether the patent system actually does what it is supposed to do. That is, we ask ourselves whether the patent system actually does transmit technological information to the public in an effective way. From a broader perspective, this question relates to the fundamental deal between a patent holder and society, which is the grant of exclusion rights in exchange to disclosure of technological information. Granting a patent holder the right to exclude others from the use of its patent invention shall offer firms incentives to invest into R&D, whereas disclosure of technological information shall support an efficient competition among technologies. By efficient competition among technologies, I thereby mean that when firms know what technologies are out there, they can either choose the technology best suited for the purposes and license it, or they can simply make better informed investment decisions. Now, most of the literature on the patent system implicitly assumes that the right-hand side of the deal is met. That is, most of the literature assumes that the patent system indeed does disclose technological information to the public in an effective way. We, however, want to ask ourselves whether this assumption is actually justified. Now, why do we ask ourselves this question? Well, at least among practitioners, there are concerns that the function of the patent system to inform the public about what technologies are protected is not always met. The quotes you can see here from a report of the Federal Trade Commission, which summarizes statements of practitioners made at several meetings and conferences, shall illustrate that. In some areas, like, for example, biotechnology and pharmaceuticals, it seems that the so-called notice function of the patent system is met. However, in other sectors, like information technology, there are serious concerns that the patent system does not inform the public about the protected technologies in an effective way. So again, what we ask ourselves in this project is whether there's evidence beyond the anecdotal ones I just presented that the patent system is intransparent. Or, in more specific terms, we ask ourselves whether there's evidence that the patent system does not meet its function to inform the public about what technologies are protected in an effective way. We try to give an answer to this question by exploiting a quasi-experiment. This quasi-experiment is constituted by a rule change which occurred in the European patent system in 2001. In 2001, the European Patent Office decided to conceal information about whether a patent applicant requested accelerated examination of his patent. We tried to exploit this rule change by first thinking about how this rule change should have affected the behavior of patent applicants and their rivals, and by then looking into our data to see how behavior actually changed. From comparing the hypothesized changes to the actually observed ones, we then try to draw conclusions on the transparency of the patent system. The quasi-experimental setting I just spoke about is related to the patent application process at the European Patent Office, which is depicted here. In its essence, the process is as follows. First, an applicant applies for a patent. Then the application gets published, the patent gets examined, and in the end, it gets eventually granted. In case a patent gets granted, there's a short time window of around 9 months during which the patent can be opposed centrally at the European Patent Office. Now, what is important here for us is that the applicant has the possibility to request accelerated examination of his patent application. What constitutes our quasi-experiment here is that before 2001, the request for acceleration was made public at the time it was made. After 2001, applicants still had the possibility to request accelerated examination, but that request was no longer made, information about that request was no longer made available to the public. Now, given this change in the EPO's information policy, we now try to first derive theoretically how this change should have affected the behavior of both patent applicants and their rivals in case the patent system is indeed intransparent. The basic framework for deriving our hypothesis on changes in behavior is as follows. We assume that there are two firms, firm A, which shall have a patent application at the patent office, and firm B, which shall be active in the same market as firm A. We assume that firm A shall have the possibility to request accelerated examination of its application, and that after grant, firm B shall have the opportunity to oppose firm A's patent. In case firm B opposes firm A's patent, opposition proceedings unfold, which are costly for both parties, and at the end of these proceedings, the patent of firm A gets granted, but remains granted with a certain probability. Now remember that we ask ourselves whether patents do disclose technological information to the public. For modeling purposes, we operationalize the technological content of a patent by the value of that patent. Implicit behind this link between the technological content and the value of a patent are the following two assumptions. We first assume that a patent applicant has, at least on average, a rather good estimate of the value of his patent. And we further assume that in case third parties could directly inspect firm A's invention, that these third parties would arrive at a similar estimate. Now, based on these conceptual considerations, we built a formal model, which is depicted here. Basically, we let firms A and B play a dynamic game of incomplete information. The timing of our game is as follows. First, we assume that nature draws the value of firm A's patent, which can be either high or low. After being informed about the draw of the value of its patent, firm A can decide whether or not it wants to request accelerated examination of its patent. After firm A's move, firm B can then decide whether or not it wants to oppose firm A's patent. In the end, we have payoffs which are realized, and these payoffs depend on the value of firm A's patent, firm A's acceleration decision, and firm B's opposition decision. Now our quasi-experiment, which is the EPO's decision to conceal acceleration information, manifests itself in the information structure of our game. We want to deduce hypotheses on changes in behavior for the case that the patent system is indeed intransparent with respect to patent value. We therefore assume that only firm A is informed about the value of its patent. Now, before 2001, we assume that firm A's acceleration decision is public, which means that at its turn, firm B does not know about the value of firm A's patent, but it knows whether or not firm A choose accelerated examination or not. After 2001, firm A's acceleration decision is private information, which means that at its turn, firm B does neither know the value of firm A's patent, nor whether firm A decided to request accelerated examination. Now we try to derive hypotheses on changes in behavior from comparing firms' strategies under the two information regimes. Firms' strategies depend on the relationships between the outcomes, and these relationships in turn depend on our parametric assumptions. The most important parametric assumptions we make are the following ones, which we tried to make in close accordance to empirical findings. We first assume that there's only a small share of high-value patents, and that the profit from a high-value patent is much larger than that from a low-value patent. We then assume that acceleration is costly, and there are gains in profits only from acceleration of high-value patents. And finally, we assume that opposition is costly for both parties, and that only opposition of high-value patents is worthwhile for the rival. Now, given this model setup and given these assumptions, these parametric assumptions, we arrive at the following two predictions. The first prediction is for the case that gains from acceleration are low. In this case, after the EPO's decision in 2001 to conceal acceleration information, we expect to observe an increase in the frequency of acceleration requests. The intuition here simply is that before 2001, applicants knew that their rivals could use the acceleration information to identify high-value patents, and with only low gains from acceleration, the applicants did not want to take that risk. After 2001, with the acceleration signal hidden, there is no reason anymore for applicants to refrain from acceleration, and thus acceleration frequency increases. The second prediction is that for the case of high gains from acceleration, we expect to observe a decrease in the frequency of oppositions. The intuition here is that applicants always accelerate high-value patents because even with a public acceleration signal, the high gains from acceleration compensate the applicants for the risk of being opposed. However, after 2001, the rivals can no longer use the acceleration signal in order to identify high-value patents, and because for the rivals, opposition of a low-value patent, so that is a miss, is costly, they refrain from opposition. So from our theory, we derived two hypotheses on changes in behavior conditionally on the case that the patent system is intransparent. The first one is that for low gains from acceleration, we expect to observe an increase in the frequency of acceleration requests, and that for high gains from acceleration, we expect to observe a decrease in the frequency of oppositions. Now we take a look into our data to see what actually happened. For our empirical part here, we use data on all patent applications at the European Patent Office. Here you can see for all patent applications of a given year, the part which was accelerated, the blue line, and the part which was opposed, the red line. The vertical line here indicates the date at which the EPO changed its information policy. Now, from a first short look at these graphs, it seems that our predictions are met. With the EPO's decision to concede acceleration information, the frequency of acceleration requests increased, whereas the frequency of oppositions decreased. Of course, these graphs are purely descriptive. In order to see whether the changes in acceleration and opposition frequencies just shown are not only correlated with, but actually caused by the EPO's policy change in 2001, we performed difference in difference estimations for the 5 main technological groups into which our patents can be grouped. The idea here is that for each area, we look at one group of patents which shall be affected by the change in the EPO's information policy and at another group of patents which ought not to be affected by the change in the information policy. Given the so-called common trend assumption, that is given the assumption that the development of the frequencies in both groups would have been the same, given the hypothetical case that there had been no treatment, any difference in the development of the frequencies indicates that there's actually a causal relationship between the policy change and the changes in behavior. So in short, the estimate here compares the development of frequencies for the group of high-value patents to that for the group of low-value patents. Why that? Because from our theory, we have seen that only high-value patents shall be affected by the EPO's treatment. In our empirical part, we try to identify high-value patents and low-value patents by using a value proxy, which simply counts the number of countries and years each patent is active in. The reason being that a patent holder has to pay fees for each year in each country he wants to keep his patent active in. Now, I get to the results. First, we have mechanical engineering, where we observe a significant increase in the frequency of acceleration requests. Here we argue that this observation is what could have been expected from our theory, because in mechanical engineering, we have mostly majored technologies assembled, like, for example, combustion engines. And for these mostly major technologies, gains from acceleration should be rather low. Our theory for low gains from accelerations predicts an increase in the frequency of accelerations, and that's what we observe here. Then we have instruments where we observe a significant decrease in the frequency of oppositions. Again, we argue that this observation is what could have been expected from our theoretical considerations, because in instruments we have mainly young technologies like, for example, medical technology assembled, and for these young technologies there should be rather high gains from acceleration. For high gains from acceleration, our theory predicts a decrease in the frequency of oppositions, and that's what we see here. Finally, let me mention that we have that the results I just highlighted are very robust, which means that they hold regardless of how exactly we define both the pre and the post-treatment period with respect to both the width and the location of the time windows our estimator compares. And that the results I marked here, the results for electrical engineering and for chemistry, are still in line with our theoretical expectations, but not as robust. So for electrical engineering, we might observe also a decrease in oppositions beside the increase in acceleration frequency shown here. And for chemistry, we might observe an increase in the frequency of accelerations. So to summarize, what we have shown in our project is that the patterns of changes in behavior which we observe in reaction to the EPO's decision in 2001 to conceal acceleration information, that these changes correspond to theoretical predictions from a model which assumes the patent system to be intransparent with respect to what technologies are protected. The interpretation we make is that this result, together with anecdotal evidence like the one shown at the beginning of my presentation, that this result hints to the fact that, at least in parts, the European patent system is intransparent, meaning that at least in part, it seems not to meet its function to inform third parties or the public about the technologies which are protected in an effective way. So thank you a lot for your attention.
Thank you, Sebastian. So the last paper in this session is by Michael Frakes and Melissa Wasserman, and my understanding is they're going to share the presentation. This presentation is an example of economists relaxing the guild rules for the purpose of this conference, allowing two lawyers to actually present in our session on the economics of the patent system. Michael is on the faculty of Northwestern University, Associate Professor of Law, and Melissa is at the Illinois College of Law. And their paper is about the time allocated to review patent applications.
So good afternoon, and I just wanted to start by echoing the sentiments of the other presenters and thank you all for being here, and in particular thank the organizers of the conference. So today I'm going to be talking about an article that's part of a larger project that looks at distortions in the United States Patent and Trademark Office's decision making. And the article I'm presenting today, with the help of Michael, empirically examines whether patent examiners are currently facing binding time constraints that may be biasing them towards allowing patents. So the motivation behind this piece is there's a lot of concern in the United States that the USPTO is issuing too many invalid patents that's unnecessarily draining consumer welfare. So what's the harm if the PTO is biased towards granting patents? Well, as we all know, patents help nudge society towards optimal innovation by giving inventors a way to recoup their research and development expenses, but they do so only at a cost. We may have less access to the patented invention and have to pay higher prices. So if the PTO is systematically applying the patentability standards in a patent-protective direction, it's likely that it's routinely allowing patents on things that may already be known. And these patents may be imposing the significant costs on society without providing us the commensurate benefits of innovation. So beyond this harm, there's also concern, as we heard about yesterday, that patents may impede and follow-on innovation. They also may impede individuals from entering the market, or perhaps there's some concern that they may be utilized by non-practicing entities to extract rents from innovators. Now, so despite the fact that patent quality is at the heart of patent reform debate in the United States, we actually have little compelling empirical evidence that there's any particular feature of the patent system that biases the PTO towards allowing patents. And so as a result, there's policymakers who are trying to increase patent quality are really doing so without understanding what features may be at the root cause of the dysfunction. And so one of the contributions we hope from this paper is to begin to provide some compelling empirical evidence about features that may actually bias the PTO towards granting patents. And we do this by utilizing an empirical methodology that rules out confounding explanations. And in particular, the feature that we're going to focus on are the time allocations that patent examiners are given. So I'm going to begin by giving you a little bit of background about the examination process in the United States. So each year, there's about 300 to 500,000 patent applications that are filed at the USPTO. And patent applicants in the US have a duty of candor to disclose to the PTO prior art that they know of that may affect the patentability of their application. Now, before a patent application enters examination, it's routed to an art unit, which is an administrative unit at the PTO that comprises about 8 to 15 patent examiners that review applications in the same or a related technological field. Now, once it gets assigned to an art unit, the supervisor of that art unit then generally randomly assigns the application to a specific examiner in that art unit. And this random assignment is going to be important in our identification strategy. Now, the examination of an application typically begins with an examiner conducting their own prior art search to supplement the prior art that's been submitted by the applicant. Then the examiner is going to turn to assessing the patentability of the claims. And examiners can really make two different types of rejections. The first we're going to say are non-art-based rejections. So these are rejections the patent examiner can make without looking at the prior art at all. And alternatively, or in addition to, they can also make art-based rejections, right? So these are rejections that require the examiner to look at the particular claims and compare them with what's out in the prior art. And we contend that these are more time-intensive, obviously because you need to do a prior art search, and then they require this delicate comparison between the prior art and what's been claimed. Now, out of these art-based rejections, which include novelty and non-obviousness, we think non-obviousness is the most time-intensive. So for a novelty rejection, right, you just need one piece of prior art that discloses all the elements of the claim. Where for a non-obviousness rejection, you typically start with a piece of prior art that only covers part of the claims, and then you have to cobble together additional pieces of prior art or rely what's commonly known in the field to render the claim obvious. I should also note, right, that applications are presumed valid. So if examiners don't come up with the rejections, then they must grant the patent. Now, although it may take, on average, several years from when you file your patent at the PTO, your patent application at the PTO, until you get a final patentability decision, on average, the patent examiner is going to only spend about 19 hours of that time reviewing your application. And so there's a lot of anecdotal evidence from examiners and from individuals in the patent system that examiners are not given enough time to do a good job, right? And so that these time allocations that our examiners are given may be one of the reasons why the PTO is issuing too many invalid patents. And so that leads us to our hypothesis. So we assume, right, if examiners are given sufficient time, that they are going to conduct their examination process in line with the patentability standards. However, if they're facing binding time constraints, that may force an otherwise competent examiner to find or cite less prior art, to make less time-intensive prior art rejections, especially obviousness, and this may lead them to grant additional patents. Okay. So how do we go about testing this particular hypothesis? So we're going to exploit the fact that the examination time given to that is allocated to an examiner decreases upon certain types of promotions. And as an examiner gets promoted up the ranks, each promotion is typically associated with a 10 to 15% reduction in the time that they're allocated to review an application. So if you look on this chart, you can see a patent examiner that is at GS7, right, has about twice as much time as an examiner does by the time they're promoted all the way up to GS14. You can also note that the time that's allocated to review an application depends on the complexity of the art. So here I'm showing artificial intelligence, which is one of the most complex arts at the USPTO, versus compound tools, which are like hammers, and that's one of the least complex art. But regardless, right, the scaling is the same. So we contend that the most significant change associated with a promotion that bears on the examiner's decision to grant a patent is the time allocated to review an application. But there is, upon the promotion within a GS level 13 and to GS 14, a change in the scrutiny of their work. So if you're an examiner and you're at GS 13 and below, all of your work is reviewed by an examiner that has full signatory authority. And you can work towards obtaining this authority once you get to GS13. You complete a successful evaluation period, you can get promoted to GS13 with partial signatory authority that gives you the right to independently sign off on first office actions. And if you complete a second evaluation period successfully, you can get promoted up to GS14, and those are the ones that have full signatory authority. So what's the methodology that we utilize? Well, we're going to track how individual examiners' granting behavior varies over the course of their career, including when they experience these examination time decreasing promotions. And this is obviously known as an examiner fixed effects design. Now, so to do this, we're obviously going to need data at the individual examiner level. And so we collected information for all 1.4 million utility patent applications from PAIR, which is the USPTO's public database, that were filed on or after March 2001 and had been published and disposed by July 2012. And this included information on the examiner charged with reviewing the application, any basis of rejection that the examiner made, and of course, whether it was eventually granted or not. Now, we also need information on the GS level, so what their sort of rank is in the USPTO on a yearly basis, as well as the experience, how much time they'd spent as an examiner. And to get this information, we filed Freedom of Information Act requests with the USPTO. And then we cross-matched all of these particular databases by the examiner name. And we treated the examiner who did most of the work on the application as the primary examiner associated with that application. Meaning, if there was both a non-signatory and a signatory examiner on an application, we treated the non-sig as the examiner that's associated with the application. And all told, this left us with a database of about 9,000 unique examiners. Okay, so I'll turn it over to Michael.
Hi, Michael Frakes, Associate Professor of Law at Northwestern University and Faculty Research Fellow at the National Bureau of Economic Research. So the question is, so what do we find? Do we see grant rates rising upon these examination time reducing promotions, as Melissa just predicted? Well, indeed we do. So this figure plots the relationship between examiner grade levels and grant rates, implementing the methodology Melissa just laid out. We see that grant rates rise markedly upon these promotions. As examiners rise from General Schedule Level 7 to GS Level 14, the grant rates increase by roughly 17 percentage points, or about 25%. In the paper, we do a calibration exercise, which actually suggests that if all examiners were given as much time as those examiners at the lowest grade level here, we would see the Patent Office granting about 100,000 fewer patents per year. So these findings we claim are substantial. Now, importantly, this analysis is plotting this relationship between grade levels and grant rates while controlling for the experience and years of the examiner. But our focus is on the grade level effects. But as a little tangent here, we may be independently interested in the effect of increases in experience and years on grant rates as well. So on the next slide here, we try to get at that. And so basically what we find, leaving aside the grade levels of examiners, we find that grant rates increase initially as examiners spend more years within the agency, but then those grant rates start to go down as examiners spend even more years within the PTO. And I mentioned these experience findings as they stand in stark contrast with a recent paper in Restat by Mark Limley and Bhavin Sampit, which documented a monotonically increasing relationship between experience and grant rates. In our paper, we demonstrate that this divergence in the findings between these two studies likely arises from the cross-sectional nature of Mark and Bhavin's analysis. They're simply taking 10,000 applications at one point in time and finding that those examined by more experienced examiners are granted at higher rates relative to those examined by less experienced examiners. The concern, though, is that this may not be a real effective experience. It may just derive from the fact that those examiners that happen to stay at the agency for longer periods relative to those that leave early on are of an inherently different disposition. So we demonstrate that this selection story may be indeed driving the divergence between our findings and Mark and Bhavin's findings. As we know, with the use of examiner fixed effects, as Melissa sort of told us about, we have a flexible means of accounting for examiner heterogeneity and in addressing any such selection concerns. Now again, just bring this back, I emphasize that the heart of our paper is not necessarily with this experience story, but with the effect of examination time reducing promotions. But importantly, our analysis also differs from Mark and Bobbin's in that we do have the ability to try to decouple experience effects from the promotion effects that were most of interest here. So with this in mind, I come to a second way in which we try to a second way in which you try to decouple experience effects from promotion effects, aside from just controlling for experience in the regressions, as we were essentially doing in that first graph that I showed you. With this second approach, we nest experience within grade levels and essentially follow examiners as they spend more time within each grade level, and then see what happens when they jump to the next grade level, and then spend more time within that next grade level, and so on and so forth. So we do this focusing on GS levels 12 and above, because it's really at this point when they start to spend multiple years on average within each grade level, such that this exercise actually we can actually implement it. So what do we find with this approach? I think this is a pretty compelling graph. If anything, this graph tells us that over the time dimension alone, it appears as if examiners begin to grant at lower and lower rates as they stay longer and longer within the agency. It is simply that this decline in grant rates over time is interrupted and reset upwards as examiners get promoted to the next grade level and sort of get this reduction in the time that they have to review applications. But subsequent, and then following that promotion, we sort of see this pattern repeat. Their grant rate starts to trend and decrease down again, and then reset with the next promotion. So overall, this may actually suggest a story in which, as examiners stay within the agency, they do get better at coming up with bases of rejections, but that they may see this progress interrupted with these examination time-reducing promotions. Okay, so just thus far I've been speaking about the grant rates. They increase with these promotions, as I've shown. But we also, Melissa also predicted that we may see corresponding reductions in time-intensive obviousness rejections upon these same events. And our findings support that prediction as well. So I show here a graph of essentially the same approach as the previous slide, but now focusing on rates of obviousness rejections as our outcome variable. So I just showed that over time, grant rates want to go down, but then are reset upwards as examiners go through those relevant promotions that leave them with less examination time. And in this graph, we sort of find a nice corresponding pattern with obviousness rejection rates, obviously in the other direction. These obviousness rejection rates tend to increase as examiners spend more time within these grades, but then these trends are interrupted and reset downwards as examiners experience the relevant promotions here. So. Go to the next slide. Now, behind these findings might be a story in which examiners are scrutinizing applications less as they become more time constrained. So to tease out this story even more, we plot how the share of prior art citations that emanate from the examiner as opposed to emanating from the applicant, how the share changes as examiners undergo these relevant promotions. Acknowledging, of course, that this examiner citation share may be a rough proxy for examination scrutiny, we nonetheless indeed find that this measure falls as examiners experience these promotions. And again, I think that this helps lend support to the main grant rate findings that we started out presenting a moment ago. So overall, there seems to be evidence that examiners may be granting more patents than they otherwise would if they were given more time to review applications. Now, if we thought that examiners were to apply the patentability standards properly if given enough time, the implication of this analysis is that the Patent Office may be issuing too many invalid patents. Can we say anything to support that notion? Well, to be honest, it's extremely difficult to do. But let me say just a few final words about at least something that we can try to do to push in that direction and shed some light on that inquiry. So we may not be able to sort of show that these additional patents being issued on the margin are truly invalid, but we may try to show that they are at least of sort of marginally more questionable value than the average issued patent. And we attempt to shed light on this by basically drawing from the various metrics of patent value used by the patent literature over time, including a number of the measures that we've heard sort of discussed at this conference thus far. So I'm only going to show sort of one graph here and for one such metric, the likelihood that the issued patent will be renewed over time. So what we're showing here is basically that average renewal rates among the set of issued patents fall as examiners experience the relevant promotions. Again, above, we showed that grant rates rise upon these promotions. And so if average renewal rates are falling as we experience these events in which the number of patents granted are rising, the implication is that those new patents that are being issued on the margin are at least of less than average quality. And so we show this not just with renewal rates, but across a range of other sort of metrics of patent value as well. So overall, what we've done here is, again, there's a sense that the U.S. Patent and Trademark Office may be issuing too many patents and too many invalid patents. And with this paper and a series of sort of other additional papers, we've just tried to shed some empirical some empirical light on that story and try to sort of understand not just is it happening, but why it may be happening. And again, with this paper, we're sort of focusing on the time allocations that we're extending to examiners, and essentially with the results that I've just shown, try to evidence at least consistent with the idea that is these time constraints are in fact binding right now, and as we sort of tighten them, we are seeing potentially examiners scrutinizing the application less, doing less intensive obviousness rejections, and granting additional patents. And again, the findings suggest that there may be sort of a substantial number of additional patents that are being issued as a result of these particular constraints. And so Melissa laid out some stories for why we should care about overgranting in the first place. So I won't sort of restate that. But there can potentially be significant deadweight losses associated with overgranting. So I'll just end on sort of one final implication, which is it's more on the equity side. Essentially the Patent Office may be treating similar applications dissimilarly, and so we might think about an applicant may just by luck of draw sort of get an examiner who will have who sort of extend them a sort of a much more permissive sort of granting practice relative to another examiner, and again, it just may be sort of by random luck of the draw. So I think they're both sort of efficiency implications and equity considerations here that are that are certainly worth considering by policymakers. And so, with that, I think that we're done.
Thank you. Thank you. And because all of our presenters were incredibly obedient in sticking to their time limits, we've now got a good chunk of time for some questions and discussion. Yeah. Somebody got the microphone?
So thank you very much for very interesting presentation. I have one question. Because
please identify yourself.
Yeah, sorry. Yeah. I'm Chiara Criscuolo from the OECD. I have a couple of questions. One is for Elizabeth Webster, because just before the sort of change in the slides, you showed a very interesting graph where you could see a drop in the Korean share of national inventor, I think, if I understood the graph correctly. And I wanted to know whether you had a sort of explanation of why that might happen. And the other sort of question I had is, you seem to have pulled together sort of, duplets and triplets and sort of multiple twins, if you want. And I was wondering whether you have looked at the heterogeneity in the treatment of these different categories. So you might think that if a firm files in different offices, the more offices, the more valuable the patent, and so perhaps the treatment is different. So that was my question for you. And the other question I had was for Michael and Melissa, and one is whether you also take into account the tenure in particular sort of areas of patent examiner, not just the experience. And the reason why I was thinking of that is that because you see that there are very sort of the standard errors of your estimate seems to grow almost monotonically within the GS12, GS13 categories. So it's not only that the coefficient declines, but the standard error increase. And I was wondering whether you had an explanation for that or whether it was just number of observation. I don't know. Thank you.
Okay, maybe Beth first, and then Michael or Melissa.
Thank you very much for those questions. They're good questions. I don't know, in the case of Korea, I'd have to, I mean, it's something, it is still work in progress, something that would be really good for us to chase up, and I'll be maybe emailing my friend Kun Lee to ask him. But bear in mind, these are international applications only. So if you look at the whole set of applications to the Korean Intellectual Property Office, it could be quite different. But treatment according to family size, again, I think that's a very sensible idea for us to follow up and see whether, because the ones that go to the 5 offices, the most valuable are the most valuable. And so you would expect them to have the best patent attorneys, the best lawyers if they're involved, or the most valuable, putting most effort into ensuring that their application gets through. And that, again, is something we would hopefully tease out. In our patent data set, there is the disharmony issue that you see pop out, which we haven't addressed in this paper, only looking at one issue. But that whole disharmony issue is another paper and a really interesting one. So thank you for your comment.
Thanks for your question. First on the idea of tenure, I would say that it's an important part of what we're doing. And so, to go back to our discussion of Mark Lemley and Bob and Sampett's restat paper, the problem there is they really couldn't decouple an experience effect from an examination, from an experience effect. And so essentially we're acknowledging there can be real tenure effects here, and we're trying to sort of capture all of those with our examiner fixed effects. And to be clear, we're almost all the specifications, every specification you saw, we have those examiner fixed effects in there, in which case we would have to sort of step back from that if we wanted to explicitly estimate those tenure effects. But I mean, that's something that, that can be done. If you go back to sort of, the graph that we had, yes, what happens as you stay within the grade levels over time, and then, and it's true. So essentially the number of observations are going down. I mean, so there's, at least at these ranges, lots of people are staying for at least a couple of years, and then some will get promoted more quickly, some will get promoted more slowly. They're in lower and lower numbers as you go, and so that is going to account for some of the increase in standard errors there. I mean, to be clear, with examiner fixed effects, we're still identifying the changes there based on true increases in experience, not pure selection, but there is, it's not just maybe a standard error concern. There might be a generalizability concern with that. So there's some folks that sort of will get, they'll get promoted relatively quickly, and it's tough for us to say if we made those folks also stay at longer periods of time as in GS level 12 and 13. We can't necessarily say with confidence, but they've sort of shown that same pattern. But what we can say at least is those folks that rise pretty quickly, once they hit that final one, GS level 14, they stay there for a long time. And so there we've got sort of nice representative sample, and we really are seeing the decline in grant rates and the increase in obviousness rejections, at least for those folks. But we definitely acknowledge what was going on there. So thank you.
Mark, and then Margaret. Wait till you get the mic, Mark, so that people can hear.
I just wanted to ask one question, to make a comment to Sebastian about the paper on opaqueness or opacity, whatever. It's interesting, the work, but I'm a little bit concerned. I mean, apart from the distinction between sort of value, real private value, and quality, and that applies also to the last paper. That we're stuck with that problem, but we have to acknowledge it perhaps more frankly. But in terms of opaqueness, the notice function stuff that I understood Peter Manel and what was it? Peter and was talking about and Mike Moyer about notice function of patents. There are two different things. I mean, one is whether or not the patent reveals, or the patent grant reveals clearly the boundaries of the property right. Okay? And that's what I understood Peter and Mike to primarily be talking about, sort of notice externality function. It's quite a different thing, it seems to me, opaqueness around or lack of clarity in terms of what the patent disclosure is in terms of the innovation itself. That is, whether I could, as knowing the state of the art, replicate the thing, which is really more about the knowledge spillovers story. Those are two very different things, it seems to me, and I wasn't really clear about whether or not you were clear in your paper on that distinction. Could you comment on that?
Yeah, thanks a lot for the comment. We are concerned about the content, the technological content. So we do not care about the legal boundaries of a patent. So maybe I misused the term notice function, and I'm sorry for that. But we are really concerned about the spillover of technological information and not about the boundaries. So we make a really simple assumption and say, okay, there's some probability with which a patent withstands opposition, and that's it. So we are not concerned at all with legal boundaries, but we are only concerned with spillovers. So sorry for the use of notice function. Maybe I should throw it out. But thanks a lot.
I think Margaret.
So I have a question for Michael and Melissa. Did you look at whether examiners who tend to grant a lot are also those who are promoted first within each GS category?
Yeah, we could offhand. Those that grant a lot are the ones that sort of tend to. I think that we have looked at it and didn't really sort of notice much of a pattern there. It's at least for those that we know sort of stay within those grade levels over at least for a little bit of time before getting promoted. It doesn't seem to be because we're seeing that decline in grant rates and the promotion, they go up. So it doesn't seem like we're finding a pattern of they just happen to get promoted at points when they start to hit particular elevated grant rates. But again, it's what I just said there. It's tough to do for those that are getting promoted quite quickly. Yeah, I'd have to go back and sort of. I think that we had looked at that, and I don't think anything jumped out. But I have to go back and to get some more exact numbers. Right there, that'd be a useful thing to do. I like that.
Thank you. Ben Mitrakan, IP Australia. My question is for Sadao Nagoko. I'm curious because I thought there's a fourth effect of grace periods, which is often discussed in Europe at least, which is the uncertainty it brings and the costs of uncertainty. And I wonder what your judgment is as to whether or not 2.8% more citations for 0.6% of all applications is worth the uncertainty.
For comments, and that's a very difficult question. Actually, I cannot really answer, but I think that I think that's an issue which we need to consider. But I think at the same time, I think that uncertainty can be controlled by the design, and as I said at the end of my presentation, for example, notification of the prior art, which depended upon by the applicant, and also earlier disclosure of the patent application based on that disclosure. I think that would probably significantly reduce the uncertainty with respect to the use of the grace period.
Alan.
Thank you. Alan Marco, USPTO. I had first a question for Beth and then a quick question for Melissa and Michael. Beth, when you're looking at the origin or the inventor, right? Just curious as to whether you looked at all the inventors, or you're looking at the first named inventor. What range of kind of nationalities did you explore there? Number one, I know it would be hard for you to look at assignees because if they're not granted, then you may not know what the address of the assignee, at least for U.S. applications. Melissa and Michael, I just wanted to the 19 hours, right, that you mentioned at the beginning seems quite low to me because that's 19 hours. That's not 19 hours for each application. That's 19 hours for each final rejection for each application. And each application may go through multiple rounds of final rejection, right? So we're really talking this could go from 19 to 20, let's say 20 hours, to 40 to 60 if they go through, if they have 2 RCEs, two continuations. And with that in mind, how would that change your interpretation of the time constraints for the examiners?
The local inventor dummy is one if any one of the inventors has a local address. So it's the, yeah. But we'll double check that. But we did have problems with getting multiple inventor information from SIPO. That's work in progress.
So that's a great question. So I think it depends on a couple things, right? If it goes back to the same examiner each time, or whether it's a continuation, perhaps goes to a different examiner, you know, because if it goes to someone new, then I don't think it changes that much. But if you go through multiple rounds, then you would, and it also depends on then how much the claims are changed, right, from each time. To the extent it's staying the same, you would expect that it would help alleviate it somewhat, right? That the second time through, hopefully they don't have to conduct that much of a prior art search, and so you would hope that that would end up sort of countering out, you know, some of the effects we find.
I would say too, and just think of this. I mean, there could be a number of stories that and others to why you know, RCEs could sort of affect what we're doing here. I won't sort of get into all of them, but you know, which has prompted us to see inclusion of RCE controls is specified in various ways as it's sort of changing the patterns that we're observing, and it's not encouragingly, in which we sort of recently put that into a revision of the draft. But anyway, that's a great question.
Okay, can we get a microphone over here? Oh, well, I'll tell you what, as long as the mic is back there, why don't you go ahead and then you'll be next. We were trying to get it here, but that's okay. Go ahead.
Okay. Gianluca Darasconi from Italy. I have a question for Professor Webster. I was wondering if you had taken in consideration the fact that within the same patent family, the addresses of both inventor and applicant may change, and probably may be helpful to identify some other effects. For example, if you have an applicant who has a local address in the application, but a different address in the priority, it will be the effect of a localization or local chapter. Or if the address of the inventor changed, there may be not a local but localized inventor. Thank you.
Do you mean change or different? Because we've certainly looked at where the address of the local inventor, or the address of the inventor is different from the address of the applicant. But I don't think we've, you know, our data sets. Oh, okay. So just to repeat what you said, where the same inventor, say it's John Smith, has a different address at different offices.
Yeah, in different application authority within the same patent family might have a different country of address.
No, I'll look at that, but that's a good point. Thank you very much.
Thank you for your patience.
Tony Clayton, UK Intellectual Property Office. Thanks very much for 4 great presentations. I thought they were all brilliant. And give us, I think, any of us who actually help provide advice to patent offices some food for thought. At least 2 of the questions I wanted to ask have already been asked and answered. I've got 2 left. One is for Sebastian, which is, surely any flag that you put on an application will change the way it's perceived in the market and the way opponents will behave. So the identification of an accelerated application isn't necessarily an indication that the technical information is any more obscure than it would otherwise be. That's not to say that it isn't obscure, but any flag will change behavior. And I wonder whether there might not be other ways of just trying to understand how obscure the information is. Perhaps you could make judgments on how complicated or obscure the information associated with patents is in particular fields, and that would probably be the best way of understanding it. And for Melissa and Michael, I mean, it seems to me that what you've shown is that experience is a substitute for time, and that patent examiners get more productive as they stay in their roles, which is what I think you'd expect from any professional, that you know, they would get smarter as they got longer in the role. Maybe not as they get older, I don't know. And I just wonder if I think some of the other questions about what happens to them through their careers is probably a really good way of understanding how offices can optimally manage the examiners they have. Because, I mean, given that people do get more experienced and more productive, it is inevitable that different applications will be treated in different ways, unless you can optimally judge the time of the experience of each examiner. How would you treat that?
Thanks a lot for the comment. Yeah, it's true. I mean, what we see basically in the data is just a reaction to an omission of a signal. Now the question is how to interpret this changes in behavior. And at least we think what's quite nice about the results is that for chemistry, we don't see a reaction. And that somehow fits our story, that it's actually information about the content of a patent which is missing, because chemistry is at least said to be a rather transparent field where you have a lot of inventions which are described by simple plain formulas, and which means that patents from chemistry should be rather transparent. Though the fact that we don't see an effect for chemistry somehow gives a little support to our stories that it may be about this technological content. So, but I mean, you're right. Basically, what we see at first is just a reaction to a signal. Now, the interpretation comes from the anecdotal evidence and also the result for chemistry, the non-result for chemistry. So, thanks a lot.
So thank you for your question. I think there's a couple things that I'd like to point out. So one is, you know, in the literature, there's a lot of this idea that why is the PTO or the USPTO issuing bad patents? It's sort of the junior examiners or the newbies that are the problem. And so one of the things, you know, that our paper does sort of suggest is, yeah, it looks like the people with low GS levels, right, actually have a much lower grant rate. Perhaps they are getting enough sort of mentoring or review to be making good decisions or having enough time. But I think you're exactly right, this sort of idea that as you have more experience, you know, it is sort of as a substitute for time. As you spend more time in the grade level, you see your grant rate going down. And one of the things I think it suggests then is perhaps maybe we just need to ease examiners into these new time restrictions that they have upon promotion, instead of just sort of the next day, them adjusting to this 10 or 15% decrease. Let's give them a 6-month or maybe a larger window to get used to those particular time promotions. Then maybe we'll actually see sort of an increase in patent quality.
Yeah, I'll take the chair's prerogative and follow up on that, because I was wondering, you know, I think you're exactly right about the conventional wisdom being there's too many bad patents, and I think your paper does a great job of pointing to a way to think about that. But if you take it to its logical conclusion, obviously, you know, infinite time for each patent isn't the right answer either. I think from your estimates, you could actually do some simulations where you either sort of calculate, if we took the current restrictions as somehow optimal, what does that imply about the valuation that we're putting on a bad decision? Or conversely, if you postulated some damage function from mistakes, you could actually like back out the optimal rate at which the time allocation should rise with the experience of the examiners. And you could actually give some normative sort of framing of how to think about the trade-off between the allocated time and the failure rate. I mean, the optimal failure rate isn't 0, but it depends on the cost. And the implication of your results is that we're not optimizing. We're sort of allocating the time that is available in the aggregate across the examiners inefficiently. But maybe you could take it a step further and actually say something about what would be more efficient.
Yeah, no, I definitely think, you know, we could move in that direction. And the paper is clear to sort of say, look, there's obviously a lot that goes into that social welfare sort of calculus. And in particular, even just the sort of trade-off between throughput and quality, right? I mean, you're obviously right. We don't want to ramp up the time allocations indefinitely because there's a distinct trade-off for the PTOs about how many patent applications that they can actually get through the system. And then, you know, there's sort of a debate about that. But even then, you know, we could definitely move more in your direction to try to quantify some particular harm versus how much cost it is for reallocating the time allocations.
Got a couple more minutes if there are another question or two. Yes.
It's actually a follow-up. Eric Iverson from NIFU in Norway. I wanted to follow up Clayton's point to Sebastian. I thought was perhaps implicit in what Dietmar talked about yesterday, that you could use the vector for non-meaningful text in the applications themselves to look into the question of how opaque or non-opaque these patents are, and then hold that against hold these vector values against what you're finding using your quasi-natural experiment.
Thanks a lot. It's a good idea, which we could implement, of course.
Anybody else? Yes, here.
I'm Yoshi Okada, Hitotsubashi University. I'd like to make comments on presentation of Professor Webster. I was a patent examiner and I was the quality analyzer and manager of the patent office. And I'd like to share the experience. I would like to share the experience among us. We investigate the applications that Japanese examiners considered patentable, but second office examiner considered not patentable. And our finding is that there are many cases the conclusions are different between first office and second office, but the conclusion, both conclusion is correct and right. There are several reasons or causes, several causes. First, translation of quality of translation is not good in some cases. So there is a slight difference between the original language and translation. And another cause is that the way of interpreting a claim is different among offices. For example, US patent examiners ignore preamble of the claim, first part of the claim, before the word of comprising. They ignore the first part. But EPO and JPO examiners consider that preamble is a feature of the technology or invention. And another case is that means plus function claim, there are difference in interpreting means function claim between United States and JPO. And another case is that claiming substance for some restricted use. USPTO examiners ignore use for some substance. They ignore that the use is not restricting the concept. But JPO examiners consider the use is a technical feature. And EPO considers, only considers the use for treatment or for disease. So the interpretation is big cause that can cause a difference between for conclusion. And because second office is built on the search results of first office, so second office can search better than first office. So first office, second office find new prior art. That might be the cause of the difference in conclusion. Thank you very much.
Thank you for your comment. Now, it is a difficult process examining these beasts. You know, no one's going to say that we expect it to be done with 100% accuracy all the time. If errors though are random, you won't pick up a local inventor effect. So some errors are going to be in the system, but they shouldn't be systematically related to any particular attribute of the application. Your point about the translation of applications between different languages and into different offices, I think it's a very good one. That might explain some of the bias in favour of local applicants, but doesn't excuse it. So if we are working towards a genuine global system where we do have national treatment, we've got to improve that, basically. Now, I don't know, I'm not close enough to what's going on to say, is it the patent attorney's fault? Because I know to apply to the JPO, if you're a foreigner, you have to have a local patent attorney. Is it the patent attorney's fault? Is it the officer's fault for not sending them back and say, you know, put it in proper Japanese or proper Chinese or proper English or whatever? I don't know. But all the point we're making is we've got to do better.
Thank you. And it is exactly 3 o'clock. So I think at that point we will go drink some coffee.